If I were Jackson, this is the closing I would give. There was no collision. There was no collision because we have no evidence of a collision. When you go back to deliberate, your verdicts are going to be not guilty, and not guilty. Well, hello, everybody, and welcome back to Buckle Up. It's the Law with Attorney Larry Forman. Folks, today we're going to be doing something very special. We're going to be doing something that I have never done on my channel before. We're going to do the closing arguments in the Karen Reed case as if I am Alan Jackson, or whoever is going to be doing the closing. I imagine it's going to be Alan Jackson. He did the opening. It might be David Yannetti. It might be Robert Alessi. But if I were to put my money on anyone, it's probably going to be Jackson. He's been the leader of the pack. Obviously, he's been cross-examining the majority of the heavy-duty witnesses. He has been here through the first trial, whereas Robert Alessi only joined during the second trial. And David Yannetti, if you remember, he gave the opening last time, and Jackson gave the closing last year, around this time. It was around June 28th, I think, or something like that, is when they gave the closings last year, but the trial also started 2 weeks later. We're actually on par of how long trial number 1 took versus how trial number 2 took. At least if you just look at the raw data, the raw numbers. Last year, we started around April 16th, and we had a verdict by like July 2nd, I think it was. And this time, we started April 1st, so we started 2 weeks earlier, and we're also probably going to have a verdict by, I don't know, June 16th or 17th. Again, 2 weeks ahead of schedule. So we started 2 weeks early, we end 2 weeks early. Seems to be kind of par for the course. This is going to be very spontaneous. I did not prepare this ahead of time. This is going to be entirely everything that I know. And remember, this is only trial number 2. So if you're going to be like, but Larry, but Brian Albert admitted in his direct examination testimony that Chloe was in the room, and then Jennifer McCabe contradicts that when she says I was coming up and Chloe was nowhere to be found. You're not going to hear this from me, or Jackson for that matter, tomorrow, the actual closing, Friday the 13th. You're going to hear only things, and this is going to be completely spontaneous, completely impromptu. I have no script, I have no preparation that I have done. I'm going to do a completely cold reading of the closing argument. If I were Jackson, obviously it's going to be also a little summarized. It's not going to be an hour. And what was Bev saying yesterday? Well, maybe I'll give you an additional 15 minutes. Mr. Jackson, shout out if you know that reference. 15 more minutes I'll give you. So 1 hour may not be enough. Jackson asked for 90 minutes. She's like, well, I'll consider 75. I will think about it. Kill me now. Anyway, with this woman, I swear, I just can't. But anyway, I am going to do however long this takes, 15 minutes, 20 minutes, probably no more than 30 minutes for our purposes. But essentially, if I were Jackson, this is the closing I would give. Oh, and before I forget, if you have not checked out our members-only content, go check it out. Membership started 99 cents for an intern, and so you can check out all of the content that we have under the paywall, and most of it is going to be Diddy at this juncture. There was no collision. For the last 10 weeks, you had to listen to testimony from various witnesses by the Commonwealth. Some of them were privy to the information in the House. Some of them were expert witnesses. You've heard from doctors. You've heard from accident reconstructionists by the Commonwealth. You've heard from accident reconstructionists by the defense. But the Commonwealth's theory of the case, we have to go down to the bare bones. What is the government trying to prove, ladies and gentlemen? The government is trying to prove that Karen Reed hit John O'Keefe with her Lexus SUV, thus knocking him unconscious, killing him either with the strike or killing him in the process while he lay there dead in the snow. And as you sit here today, as I'm sure you're wondering, where's the evidence? Where's the proof that that happened? The lead investigator, I told you from the beginning, in opening statements, you may recall, that there is a cancer that permeates throughout this case. And his name is Michael Proctor. You have heard his name on multiple occasions. You have heard his name being thrown out and talked about You listen to Yuri Buchanan read his texts, his vile, disgusting texts where he calls Miss Reed the C word. I'm not going to repeat it before you today. He insults her. He says, "Oh, don't worry. The guy in the house is not going to catch any shit because he's a Boston cop too." There is a reason you have not heard from Michael Proctor in this case, ladies and gentlemen. The state couldn't even call him to the witness stand. That is how much he botched this investigation. The government knew that if they were to call Mr. Michael Proctor to the witness stand, their whole case would completely fall apart. And they know that. That's why they didn't call him. Now, we didn't call him either because, as you all know, we don't have a burden. We don't have to call Michael Proctor. That's their job. Why should we do their job for them? They also didn't call a single person from inside of the house. They never called Brian Higgins. They never called Brian Albert or Allie McCabe. They called Jennifer McCabe and a known perjurer now, Carrie Roberts. Objection. There's probably going to be an objection if he calls her like a known perjurer because she did perjure herself. But anyway. But ultimately, it was Welcher who sank the government's case. Their own expert witness is the one who is going to be the determinative factor. When you all go back to deliberate, their own witness, Dr. Welcher, is going to be the determinative factor as to why, when you go back to deliberate, your verdicts are going to be not guilty, not guilty, and not guilty. Allow me to explain. Dr. Welcher took that witness stand. He sat in that chair and with a straight face, after getting paid nearly $500,000 for his opinion, he stood there and at 2 miles an hour had some colored paint transfer from the Lexus SUV to his arm. Now, he all but admitted to you that he did not conduct any calculations. He was operating outside the realm of physics. You've heard from our experts, Dr. Wolf and Dr. Rentschler, and they both explain to you in excruciating detail how, from a physics perspective, when you actually apply the scientific method, which Welcher completely failed to apply, and which I actually tried asking on a direct examination of my own client, but the judge wouldn't let me. Obviously, he cannot say that, but I'm just telling you all. And Dr. Wolf explained that at 10 miles an hour, the taillight would barely crack. You saw the evidence of his experiments. We actually conducted real-world experiments to show you how it is impossible for the 5mm exterior plastic, let alone the inside diffusers, which were broken in that taillight. You've seen the compare and contrast between the taillights after the experiments at 10 miles an hour, 17 miles an hour, 24 miles an hour, and 29 miles an hour with the Rescue Randy and the taillight itself when the arm was suspended from the air and when the crash test dummy was suspended from the air. You saw with your own eyes what an accident like that should look like. None of that paint transfer stuff. All you've learned from Dr. Welcher is that he has a shoulder and his arm is on a swivel and his arm can move. Because a dynamic test, as he called it, and I cannot stand here with a straight face tell you all that this is a proper characterization from a scientific method perspective, which once again Welcher failed to do, that going 1.92 miles an hour is not going to give you the same impact of what the real world is like when it comes to car versus pedestrian accident. At the end of the day, folks, you have to remember, the government is alleging a 6,000-pound vehicle has collided with a pedestrian in the snowstorm and has caused absolutely no damage to that Lexus SUV except for the taillight. Now, from a medical perspective, once again, we have no broken bones. We have no fractures. We have no impact area. We have no bruising. There was no collision, folks. There was no collision because we have no evidence of a collision. For the last 10 weeks, the government has made enormous attempts to try and pull the wool over your eyes. The government tried to call witness after witness who would say things like, well, she said, I hit him, I hit him, I hit him. And yet, all the other evidence points to the contrary. Now, I know what you're thinking. So, what did happen that fateful night? That is not your concern at the end of the day, because the case before you is very straightforward. You have 3 charges before you: murder in the second degree, intoxication, thus causing an accident and leaving the scene. Those are your 3 charges. This is what the government has charged my client, Ms. Karen Reed, with. Those are the only 3 charges that you are to concern yourself with when you go back to deliberate. It is imperative that you look at the evidence. And what does the evidence show once again? There was no collision, folks. You've heard from Dr. La Posada. She explained to you all that it is beyond the pale that there was an impact between a vehicle and a person. I've also heard from Dr. Russell that this is evidence on John O'Keefe's right arm that he was bit by a dog. We don't know exactly what happened, and it is not your job to determine how his injuries occurred and why, if he fell backwards, if he was hit, if he was bit. That's not your job. Your job here today is very simple, and it boils down to 3 things. Number 1, there was no collision. If there was no collision, automatically you vote not guilty on charge number 1, not guilty on charge number 2, and not guilty on charge number 3. Number 2, you do not need to concern yourselves with who might have done it or who could have been the culprit. The government is charging Ms. Karen Reed in this case. She is the one on trial, and it is your decision and your decision alone to determine her freedom. And number 3, I'm going to say it again because of how important it is. There was no collision. The government has been standing before you for the last 10 weeks to trying to bend over backwards to try and portray this insane, far-fetched theory that somehow Karen Reed hit John O'Keefe with her SUV. But they were not able to do it. They tried every which way. They called witness after witness to try and prove, and it's their burden. We don't have a burden. We don't have to prove or disprove anything. But we did. We brought in the ARCO witnesses. We brought in doctors. We brought in Karen's friend who was there that night she explained that John O'Keefe was in good spirits. He was happy. He was loving. There was no anger between the two of them. They were in a loving relationship, which brings me to the voicemails. Karen was angry because she got jealous. Karen thought that John was with another woman that night. They were in a loving, amicable relationship that night. And she got angry because she thought he was with another woman. And as a result of that, she reacted like any scorned woman would. She left him voicemail after voicemail after call after call after voicemail after voicemail after call. 57 times she called his phone. 57 times, folks, in the span of a couple of hours. Most of them were done in the span of a couple of hours. She was an angry, scorned woman who thought her man was cheating. Not only was he cheating on her, he left his kids in her custody and just ignored her. She was not angry at him before. She got angry because he didn't come home. Something happened, and that something led to his body being found on the front lawn. But it was not Karen who did it. It was somebody else. And once again, I remind you, it is not your job and it is not your duty when you go back to deliberate to determine, well, who could have possibly done it or who is the culprit. That is up to the courts. The most important piece for you to determine, because there was no collision, is to determine whether or not Karen committed this offense. And the evidence unequivocally points to the fact that she has not. And therefore, your verdict must be not guilty, not guilty, not guilty. Now let's talk about what happened that evening on January 29th, 2022, from the moment the Lexus SUV was picked up in One Meadows, which is John's address where Karen's Lexus was, because that's where she stayed that night. Even though she threatened to leave, she stayed. The Lexus SUV, you saw uncontroverted, unequivocal, unbiased, unedited, raw footage when Nicholas Barros was taking that witness stand from Dighton PD. Back then he was Canton PD. You saw with your own eyes a taillight that was completely intact. And for some mysterious reason, later on in the evening, and you heard from Ms. Dever, who admitted to you that she had created a false memory. It was not a false memory. She is covering for her friends. The thin blue line. You've heard of that, folks. I'm certain of it. She's protecting Chief Berkowitz and Brian Higgins, both of whom she said to law enforcement that came to interview her. FBI, ding, ding, ding. Law enforcement that came to interview her, she said to them that she found it suspicious that Chief Berkowitz and Brian Higgins were in the Sallyport for that long, alone with Karen's SUV with nobody else around. And she saw them on the cameras. Why? Because she was working dispatch that afternoon. There was no false memory, folks. Because just like there was no false memory, there was no collision. Karen Reed did not hit John O'Keefe with her SUV. And the government failed to prove that beyond a reasonable doubt, which is their burden. Folks, at the end of the day, you have all the power. And when you go back to deliberate, I urge you to very carefully review all of the evidence that has been presented to you. I urge you to review the videos from Dr. Wolf's and Dr. Rentschler's tests that they have conducted using the scientific method, using actual physics. You see, because the problem is when physics comes into play, their case completely falls apart. The only way they can successfully prove their case to you is by attempting to use paint transfer in fantasy world. They want you to believe that we live in a cartoon, in a imagination land, outside the realm of reality and physics, where laws like gravity and math apply. One thing that really eludes Dr. Welcher and the other Commonwealth experts is that the minute you introduce numbers and formulas to their hypotheses crumble and collapse under their own weight, as you have seen with actual experiments, actual data, actual demonstratives and demonstrations of what happens to an arm at a 10-mile-an-hour collision. What happens to the taillight? If the taillight were to shatter, as the government claims, the back of that Lexus SUV would have been completely destroyed to high heaven, just like you've seen with the Rescue Randy. That was experiment F by Dr. Wolf. It is beyond the pale, folks. There was no collision. There was no collision. There was no collision. And I urge you, when you go back to deliberate, you come back with the only verdict that is merited in this case. And that is charge 1, not guilty. Charge 2, not guilty. And charge 3, not guilty. Thank you very much.